SJC-13054, Shaw's Supermarket, Inc., the Margarita Melendez.
Okay, please help me with your last name.
Coppice.
Okay, great. Attorney Coppice, your turn.
Thank you. May it please the court. This matter is currently before the court following a reservation and report from the single justice of the Supreme Judicial Court for Suffolk County. The plaintiff in this matter, the plaintiff appellee Melendez, filed her complaint on September 24th, 2020, following an incident that occurred on September 3rd, 2017. There's no dispute that the plaintiff suffered injury at a Shaw's Supermarket on September 3rd, 2017. In response to that complaint in the Dudley District Court, Shaw's filed a motion to dismiss pursuant.
We know the case.
Thank you.
So section 12 of the second order, the second COVID order, deals with the statute of limitations. And it talks about all civil statute of limitations are told from March 17th through June 30th, 2020. Then there's other sections of the order. And this is true of the third and the fourth orders as well, like court order deadlines and expiring injunctions in similar orders. And there, the language we use is different. There, we make sure we say that expire any time from March 17th until June 30th. That language that expires any time from doesn't find its way into the statute of limitation sections of the COVID-19 orders. Isn't that a real problem?
I don't believe so, Your Honor, because the statute of limitations is in and of itself a deadline, a statutorily prescribed deadline. And so once the date for the accrual of a cause of action is established, which here there is no dispute, it was September 3rd, 2017, that's a 3-year deadline. And I believe the court's order is clear, and it says all civil statutes of limitations. And when you understand that the statute of limitations is a statutorily prescribed deadline, here, Chapter 260, Section 2A states 3 years. The deadline here was September 3rd, 2020. It didn't fall within the deadlines expiring, the statute of limitations expiring between March 17th, 2020.
What is the plain and ordinary meaning of told?
I believe you have to look at the term all with told in this context. The court's order is clear that it says all civil statutes of limitations. It does not say all civil claims, as the plaintiff argues. And when you look at the word all, it refers to the civil statutes of limitations, meaning all the different types, a 3-year tort, personal injury.
What is the plain and ordinary meaning of the
Right,
word
thank you.
told?
Told would be for the expiration of the statute of limitations, that deadline is told,
It
that it's
stopped.
paused.
It
that,
stopped.
that particular statute of limitations is paused or told. But that would be for those that fall within that deadline, because the statute of limitations is a deadline, and that deadline is what is told when you're tolling the statute of limitations.
Do you have any case law that supports the proposition that when a statute of limitations is paused, it only applies to those statutes of limitations that expire during that paused period?
The cases that I found reference only the expiration of the statute of limitations. For example, when a statute of limitations is told for equitable reasons, the courts look to the expiration of the statute of limitations. The cases, again, with equitable tolling, they look at the deadline. It's always the deadline of the statute of limitations that is expiring that is then told further. Those are what the cases that I have found that I have found state.
I'm sorry, so I don't understand your answer to my question. Have you found any case law which says the statute of limitations is told that there applies that term, that terminology, to say only those statutes of limitations that expired during this paused period are extended?
I have not found them where they toll it within the 3 years. They toll the deadlines at the expiration of the statute of limitations, the deadline on which the statute expires.
So you're not aware, as counsel for Shaw's, of any agreement that Shaw's would have entered to toll a statute of limitations during, say, for example, settlement negotiations that would have applied in the way that the plaintiff is trying to apply it here?
Such agreements tend to come into place when the statute of limitations is set to expire.
No, but but let's just say Shaw's admits liability and it's just trying to settle, right? It's like, how much is the slip and fall going to be? $1,000 or $100,000? And they're just trying to come to a number. And so the question is not liability, just the damages, and they just need some time to discuss that number. Are you telling me that Shaw's has not entered into a tolling agreement for the statute of limitations that pauses the expiration of the statute of limitations?
No, Your
Only
Honor.
at the end?
No, Your Honor. With respect to such a tolling agreement, there would be a written agreement tolling the expiration of the statute of limitations to allow those discussions to take place.
And in that context, the tolling of the statute of limitations is a hit of pause. All the negotiation periods don't count against the statute of limitations, right?
But they apply to the deadline because.
Yeah, they
it's-
extend the deadline by however long the period is paused.
And it's expected that that deadline falls within that negotiation.
Where is
period.
that part? That's the problem I'm having with your argument, is that expectation that the expiration happens during the pause period. I've never seen that.
You'd have to go and look at you'd have to look at the facts and circumstances of that particular negotiation. In my experience, when we've entered into tolling agreements, the deadline is coming. And so you look at the deadline and you agree to extend it. And so here, the deadline for this statute of limitations on September 3rd, 2020, was so far outside of the provisions set by the court, which was March 17th, 2020 through June 30th, 2020. And so I don't think that the statute of limitations was so close. If, for example, there was an agreed upon tolling, that would have been considered. There was nothing that extended this statute of limitations. And I believe there would have to be a fact and circumstances type of analysis. Whereas here, we're looking at the interpretation of the court's order. And I believe that looking at the language of this court's order describing all civil statutes of limitations, it would simply apply to the statutes of limitations that apply to the cases in the types of civil statutes of limitations applying to those cases set to expire between March 17th through June 30th.
Well, why wouldn't the court have ordered that? Why wouldn't it have said all statute of limitations set to expire during the tolling period are tolled?
In this case, it sets the effect that it would have the effect to toll statutes of limitations well into the year 2026. For example, a civil breach of contract that occurs on January 1st, 2020 is now tolled 106 days in the year 2026.
Right, which is exactly what the plain meaning of this order seems to suggest.
And the example that follows the order, the example in section 14 as well.
The purpose of the orders all state the same purpose at the very beginning, was this court intended to safeguard the safety and safety and welfare of the public and the court personnel while increasing court business. And so to do that, there has to be a stop to it. And I would like to analogize the court's criminal statute of limitations language as well, because to take the same argument that the plaintiff makes and apply it to the criminal statute of limitations, it makes an unreasonable argument for the criminal statute of limitations as well.
Well,
because-
criminal law is a lot different than civil law. I mean, I would suggest you make a different analogy.
If I may, Your Honor, it was just with respect to the language of the order and the court's reference in the orders with
No,
respect
but
to
you
the
know, in
limited
criminal context, you've got all sorts of due process issues, speedy trial issues. I mean, you can do what you want with your 15 minutes, but I think that analogizing a civil statute of limitations to the due process issues and the speedy trial issues that come up with criminal trial is probably not your best argument.
I'm sorry to go back to my first question, but do you have an explanation why, when it comes to the other provisions dealing with statutes, court rules, standing orders, guidelines, injunctions, that the order carefully says that expires anytime from March 17th until June 30th, and that language is not in the statute of limitations section? Is there some reason? Because we can't just assume that we decided to write it in 2 sections or 3 sections and not in another.
Well, Your Honor, when taken together, again, the statute of limitations is a statutorily prescribed deadline. It is set by statute. And so even if you look at, and I'm going to refer to the third order, I believe it's section 14, where that deadline term is used, a statutorily prescribed deadline, such as the statute of limitations, still falls within that time limitation of March 17th, 2020 through June 30th, 2020. And so again, it has to be read, I believe, together because the civil statutes of limitations are prescribed deadlines. They promote.
No, but you can have a more specific result as it relates to statute of limitations than you do for discovery disputes or tracking orders in Superior Court.
And if this court so intended to add 106 days, which I calculated on and between March 17th through June 30th, if this court so intended to add 106 days to every statute of limitations, it would have done so. There are statutes that allow for such additional time to an expired statute of limitations, and this court didn't do that with respect to the COVID-19 orders.
Well, only if we look at the order and read it in the way that you suggest it should be read.
But I do believe that's the reasonable reading of this clear language, that all civil statutes of limitations, not all civil cases or civil claims, all civil statutes of limitations.
Well, I mean, how would you write this? All civil claims are told? Is
Well,
that
that's
what
how
you're
the-
suggesting?
The plaintiff argues that all means all, and that it means all civil cases. That's on page 4 of the plaintiff's brief.
Yeah,
That is
but
not what this language states. It states
paragraph,
all.
paragraph 14 or section 14 also has the word statutes in it too. So it's not just rules and court orders. It's 14 has the word statutes. It just doesn't have the word statutes of limitations. We carved out statute of limitations. So I'm confused by, I still don't have your answer to Justice Lowy's question. Why does the word statute of limitations have a different language than this other provision, which deals with statutes, court rules, and other things? What's the explanation?
Because I believe the clear meaning of a statute of limitations is a deadline that expires in which a plaintiff can bring his or her claim. And so here, that statute of limitations was, in this case, September 3rd, 2020. It did not fall within the time period of the statute of limitations being told. And again, the effect of that having, going into 6 years from now, I do not believe that's the clear intent of these orders.
Well,
So
counsel,
your
what do you
position
think-
is that the statute of limitations is a date certain?
Once the accrual date is determined, which
Right.
sometimes can be,
Right, but let's just say the accrual date is determined. Your point is that the word statute of limitations is a date certain.
yes, Your Honor, from the date. of
Okay,
the
as
accrual.
opposed to a period during which a claim can be filed. So the statute of limitations for whatever, let's say a contract action is 6 years. Your position is that there is a date certain tied to that statute of limitations as opposed to during that 6-year period.
I do, Your Honor, and that's because the courts, including this court, have referenced the statute of limitations deadline, that the statute of
Right, the
limitations is a
that's
deadline.
interesting because the deadline is a date certain, that's for sure. The statute of limitations seems to me a period during which one may file a claim.
Right, and
Whereas the
statute-
deadline is a date certain.
But I believe that the statute of limitations is in of itself the setting of a deadline. And so when you look at that taken in the context of the court's order,
And so when you pause the setting of the deadline, just taking your logic here, don't you extend the setting of that deadline then? You just pause it during that period?
if it fell between March 17th and June 30th.
So you're reading all statute of limitations deadlines are told. That's what you're suggesting the orders say.
That is what I'm suggesting a clear reading of the order is.
Okay.
Well, counsel, can I ask you a different kind of way into that point that Justice Wetland's making? And that is, considering where this court was when the orders came out and we were facing the beginnings of this pandemic and many things were uncertain, what do you think our intent was in general? What were we trying to achieve with these orders?
I believe the court was trying to protect those statutes of limitations that fell within the governor's shutdown and limited business operation orders. And I agree, we were in an unprecedented situation. The COVID-19 pandemic, we had never experienced that before, but the courts
Why
were
is it
open.
limited to the governor's order?
And with respect to just in general, the court's business during the COVID-19 order. I believe it was the immediate response was with respect to that. But as of July 1st, in accordance with the orders, the courts were open. They were open for business, for emergency and non-emergency business, so that pleadings could be filed in hand or by mail, or by Dropbox. And so as of July 1st, when the statute of limitations that had been told could renew and start again or added on as of July 1st, then the pleadings could be filed. But
So
again,
your
the September
argument is that, your argument is that the order was really just designed around court business only, and whether we were functional, not with regard to whether the rest of society was functioning okay.
No, Your Honor, I believe that the means to file pleadings were still available.
Right,
The
I
old
understand that. But just because the means to file pleadings were available, was that the only thing we could consider? Couldn't we consider whether people, how the pandemic was affecting people's lives and how that might affect their ability to litigate?
Of course, Your Honor, but I believe that if that was the case, that the civil statutes of limitations had to be extended further, this court would have extended it in its fourth order, and it did not. It said they were told during this time period. And in the fourth order, I believe it's even more specific that those deadlines set to, the statute of limitations set to expire between March 17th through June 30th were added on after or on July 1st. And I believe that leads to the conclusion that they had to expire in order to be added on as of July 1st.
Does anybody have any further questions? Great,
Thanks,
thank
Chief.
you.
Thank you.
Okay, Attorney Caplet. Oh, we can't hear you. I think you're on mute.
Sorry, I think I'm online now.
Yes.
Can you hear me now?
Yes.
Good morning. May it please the court. As we've heard, there are three distinct orders here that we feel are applicable. The first is the second order dated approximately March 17th. Then there's the third order, and there's the fourth order. We would submit that they are consistent in one regard. They talk about all statutes of limitations for civil cases. And they suspended, or I'm sorry, told that on the first two orders. And at the end of the second order, the tolling is finished, and the third order references that. But all three orders do one thing. They do not, or they do several things. One of the things is that they do not break out into different classes of cases, such as the Shaw's would suggest, that cases that whose statute of limitations expired prior to June 30th get one treatment, and statute of limitations whose statute date did not expire before June 30th have to hold on to their traditional.
But what about this, counsel? In the second order dealing with the statute of limitations, the example given is an example that falls within the March 17th to September 3rd date. So, excuse me, to the June 30th date. So the example is of a situation where the statute of limitations expired within that period, as the defendant is suggesting. And the third order says all statute of limitations that were told will not be told further. And the third order repeals the second order. Is any of that a problem?
Well, 2 points. One is that you've used the word example, which is what's used in the order. It is just that, it's an example. And it's a hypothetical as to what date this court decided to choose. They happen to choose dates within it. However, they did not specify that it applies only to those dates. They gave a general order, which we submit applies to any case. There is no specification, no breakdown. Again, we would submit that in both of the all these orders, that there is a breakdown of types of cases. Statute of limitations cases we submit are treated one way, and cases involving orders and time limits and whatever else the order provides for are treated with different dates. And what is the importance of that? The importance is that as the reader, as the litigant or counsel in the field looks at it, that they're being treated differently. And it's a natural reaction. It's important to understand that not only is the intent of the court extremely important, but the impact upon the reader. When we receive these orders, what do they mean? How do we interpret them? I think is just as important. And the plain English reading of these orders is clear that it applies to all civil statutes of limitations. And it sounds like we're beating the same drum over and over, but we can't change the language. That's the language that was used.
There's at least one note that's different, though. I certainly agree with you as it relates to the second order. My question, though, that you haven't answered is that the second order gets repealed and the third order states that all statute of limitations that were told from 3/17 until 6/30/2020 will not be told further. Is that an issue that poses a problem for the plaintiff?
We would submit no, because if you use the formula of the second order, assuming we started on July 1st, we still would have filed within the time allowed us by law. In other words, we added the dates that we had as of July 1st, and if we filed it on September 24th, I believe, that would be within the 170 days. I think there's a little discussion whether it's 166 or 170, but we would have filed it within 166 days or 170 days of July 1st. So it's a rather moot point, because at that point, once it's repealed, we would submit that the time limit, the example period, if you will, exists. We have the 170 days in which to file, which it was done. Continuing on, the breakdown of cases is, my name. The breakdown of cases is consistent in the second and third orders. And interestingly enough, in the fourth order, although it only repeals affects the criminal statute of limitations by footnote, and it goes back to referring to the civil statute of limitations, and the paragraphing, the sentence structure is that it separates that from the other claims. And it breaks it down into the different categories of the same claims that were discussed in the second and third order. And we would submit that, again, there's a breakdown here done by the court intentionally, that statute of limitations are being treated in one fashion, and that the other claims, injunctions, court orders, deadlines, et cetera, will be treated in another fashion. And we suggest very strongly that the plain English reading is that all is all is all. Last, we would suggest to the court that the fourth order, even if we assume the second and third are suspended, overruled, written out, call it what you will, the fourth order, again, references the same statute of limitations period as the first two. And that's where we are now. The complaint was filed during the fourth orders period, which began September 1st of 2020. So we would suggest that the orders that would apply would be the fourth, the third, the second, in that order, because those are the time periods that we were using. There's nothing much more we can add to this beyond beating the drum that all is all is all. And there is no differentiation between the classes of cases, except as provided by the court in the subsequent paragraphs, in the second order, the third order, and it continued on to the fourth order. It's very hard to argue anything less than all is all. I would just suggest to the court that this is an epochal time period. It's the only way to express it, in which a lot of things had to be rearranged. And I can find no cases, I submit there are none, for a similar time period, going back, perhaps the last epochal type event was the Spanish flu, 1919, 1920. I have not familiarity with any cases from that time period that dealt with quote unquote statutes of limitations problem, or how they treated it, if they treated it back then at all. So there is no precedent, if you will, how we deal with epochal events here in the Commonwealth. I suggest that the court acted appropriately in doing what it did by extending the time period. We seem to have filed it well within what we believe to be the time period, the 170 days. I believe it's actually 24 days late, or 23 days late, call it what you will. And that's when it was filed. So that's why we are here today. We suggest all is all. The defendants would have you believe that all means only a few, without specifying how they can define the few. There's nothing in the court order that says what the few will be for statutes of limitations. It does define it in other categories. It does not, however, define it here. I think that litigants, counsel, the public has a right to believe that all means all. That would be our submission. There's nothing more we have to add.
Okay, thank you very much.